Me here. If you like to be, that's fine.
Okay, I could be on the.
Whichever,
You guys are having a good conversation. Why don't I get over
whichever
here on
way
this
you
side?
want to be.
Yeah, I'll
So,
get on the other side over here, Mark.
all right.
Get in there.
Well, welcome for those of us joining. This is the initial meeting of the Stable Token Commission, and so far there are 3 members of that commission: a good treasurer to my right, a good auditor to my left, and myself, the governor. We have an agenda for today, and let me just at the outset state that at least my impression of this meeting is to sort of level set. I had a good talk with Charles Hoskins a little bit earlier, and we wanted to make sure that we kind of got a number of initial matters kind of on I guess, a timeline. So the agenda that, as I have it, has the introduction of the members, review of the enacting legislation, some discussion about additional board members that could be put forward. With the role of the Attorney General would be, I really want to open this for general conversation on timeline, deadlines, reports, and those things that we need to know that we may not know now, and then potential first steps in what we do with that. And that should take care of today's meeting. And I'm hoping in the future, Mr. Treasurer and Madam Auditor, that we can meet in a little less formal setting, because I think having a whiteboard would be very helpful during some of these conversations. But in any event, Betsy, do you want to lead us through kind of an introduction to the enabling, and who is here from the Attorney General's office? Great. Sorry, Devin, you were hiding behind a post. Thanks. We'll recognize you.
All right. Kind of towards me. All right. Okay. Commissioners, Governor, Auditor, Treasurer. So my intent here is I'm just going to kind of walk through page by page, not line by line, of the act. If you have any particular questions, certainly stop me and I will make an attempt to answer them. But otherwise, or if you have particular sections you'd like to focus on beyond just a general walkthrough, I can do that as well. So if you have a copy of the Stable Token Act, just start at page 1. Obviously, the very first section is just the title. But skipping that to the next sections, the definitions, pretty general, nothing terribly exciting there. Just some general definitions for some of the terms used in the statute. And so then getting down to near the bottom third of page 2, with 40, 31, 103, actually talks about the creation of the commission, specifically creates that you3, that the auditor, treasurer, and governor are members of this commission. And then turning over to page 3 there at the top, you, Commissioner, Governor, mentioned that you're currently the members, but the statute here in this section at the top of page 3 calls for appointing 4. They say, and they do not define, but they have 4 subject matter experts in virtual currency and financial technology, appointed by a majority vote of the other 3 members, and that those members would serve at the discretion of the original 3 members. And then there's also a provision that those 4 would be subject to a background check. And then that's that section. Then the bottom of page 3 in section 104 very general but basic statement that the stable token is virtual currency that represents and is redeemable for $1. It's held in trust, and that they're only issued in exchange for dollars. And then beginning near the top of page 4, with section 105, that's probably kind of the meat of the statute, sets forth your powers and responsibilities. First one being that you administer, that the commission as a whole administers this statute, and that it has authority to adopt rules and regulations to administer the statute. So I don't know that we're at a point where we could really discuss what those would look like, but at some point, when we get to further down the road, we probably would want to look at adopting some sort of rules and regulations, at least authorizes you to do so. And then beginning in subsection C there, about the midway on page 4, it's your discretionary duties. The commission may issue stable tokens. And there's some more about that later, about whether you do or don't. But here it says that you may issue the stable tokens, provide for matters related to their issuance, including the number of them. These things can be addressed partly in your rules. You can retain professional services, such as accountants, auditors, consultants. Enter into contracts to retain contract for services from financial institutions to do your work. Ultimately select a financial institution to manage the stable tokens, the bottom of page 4. Turning to page 5, Romanet 5, there at the very top, provides that the commission may seek guidance, rulings, and other guidance from the federal government. It enumerates the Treasury, the Internal Revenue Service, the Securities and Exchange Commission, but also allows for other relevant federal agencies. So again, just maybe like as in the rules instance, like you may want to further down the road as it becomes relevant, may want to seek, and you have the authority to do so at your discretion, seek guidance from the federal government to the extent you believe that appropriate and applicable. Also permits you to utilize the state treasurer's office's services in investing and managing that account. And then finally, the authority to employ a director and employees as necessary to carry out the duties of this act. And all those employees are also subject to background check. So those are your discretionary duties. And then there's the mandatory, again, about 2/3 of the way down on page 5, where the commission shall. So the other ones were may, those were all optional, but the commission shall maintain, invest, reinvest the funds received for issuing stable tokens in accordance with investment policies that you'll establish through rule in consultation with the Treasurer's Office. You will oversee and review and audit operations and transactions implemented pursuant to this act. Turning to page 6, the last of kind of your duties section, there's subpart E there at the top, that before you issue any of those stable tokens, the director that you will have hired and appointed shall provide a comprehensive report to certain legislative committees. Here they're enumerated as the Select Committee on Blockchain, Financial Tech, Digital Innovation Technology, and the Joint Minerals Business and Economic Development Committee. So that's sort of the meat of your responsibilities. And then what the next section, 106, defines what these stable token accounts, so it said you're managing these accounts. 106 lays out what those accounts are, that it's a trust account into which you put the funds received from the purchase of these stable tokens and their issuance, that you hold those in trust to support the redemption, do not expend them for any other purpose, just fairly limits what they're for, limits the investments to United States Treasury bills, and makes clear that the state has not had a fiduciary duty with response to token holders. In subpart B, requirement that no less than 100% of the notional value of all outstanding stable tokens remains in that trust account. So if you say have 100 stable tokens issued, there's at least $100 in the account. And then at some point, if you were to get an excess of 102% of that, it provides for what you do with the excess there. In subpart C, beginning at the top of page 7, lays out kind of an order of operations of what happens to those excess funds. So they're first used to pay for the operational costs of the act. So again, as noted before, you have authority to hire, director and employees, but also auditors and experts and so forth. So those would be some of the administrative expenses potentially, as well as probably whatever fee related to the financial institution managing the funds. Those are to be paid for first. And then there's Romanet 2 under sub C that provides that you can also save for future expenditures. So if you're aware of things that maybe are not currently expenses, but will be expenses, you can save for those as well. And then the remaining of funds, if there are any, whatever those are to be distributed on a quarterly basis into the school foundation program account. So that, like I said, 106, it's just addressing what is this account, how is it managed, what are the funds used for. Then about midway down on page 7, section 107, the redemption explains how folks go about redeeming. I mean, not so much the how per se, that establishes some of that would be done through what your rules would say how that works, but what they're redeemable for, that they are redeemable for $1 essentially upon demand. And states that the value of the stable token shall be $1 for one stable token. It has an exception there if for some reason the interest rate on treasury bills, which are what the stable token trust fund account is to be invested in, if that has a negative rate of return, or for some other reason there's less assets available than there are stable tokens, that the redemption shall be the liquidated value of the treasury bill redeemed to pay the demand as determined by rule of the commission. And then that in no case shall the redemption result in the state paying a higher amount than the total assets in the stable token count divided by the number of stable tokens. So I think this goes back to just keeping the numbers relatively simple. If there's 100 stable tokens and say you have $99 in the account and someone redeems their stable token, they don't get $1, they get essentially 99 cents. But then of course that's also, you take out the administrative expenses, so it may be less than that, but that would be the basic idea. Section 108 and 109 on page 8 are relatively similar. 108 is just a notice that'll be given on any contracts and agreements and documents issued essentially by the commission, that is a notice to parties that that the state is not, of what limitations there are on the state's liabilities for the issuance of any stable tokens. And then 109 actually sets forth what those limitations are, that the state shall not be liable beyond the notional value of the fund, that the stable tokens are payable and collectible solely out of that account. So there's, for whatever reason, somebody tries to collect funds from another account, they cannot do so. It's just from that one particular account. And then beginning on the bottom of page 8 provides that the board, the state, and employees of the commission shall be entitled to immunity, liability, including defense in connection with any contract or transaction involving or related to stable tokens. Essentially, if a person does bring a lawsuit, the state has immunized itself from suit, at least in state court, with regards to those kind of lawsuits brought on that basis, on the basis of duties under this act, as related to the issuance of the tokens. So that's the main body of the codified parts. And then what's remaining on pages 9 and 10, I mean, 10 I won't really go over it, it's just the effective date of the act. But it's there on page 9, beginning about a third of the way down in section 2. This gets to the Chairman, Governor, you mentioned about the timelines. This is the first one first section that specifically mentions a timeline and states that the commission shall endeavor to issue at least one token not later than December 31, 2023. So notwithstanding what I mentioned above, where it's discretionary that you issue them, there is this section that states that you shall endeavor. Does not define what that means precisely, but says that you shall endeavor to issue at least one before that date. And then B is where we get into the Attorney General's duties. I can cover that a bit more fully later if need be, but essentially what it says here is that the Attorney General's office, the Attorney General shall monitor the startup phase to ensure that the actions taken are are permissible under federal and state law. And the Attorney General is authorized, or maybe not so much authorized, as has a duty to determine whether the issuance is permissible under the circumstances and advise the commission accordingly. And if the commission determines based on that advice not to issue a stable token, then the director that's been appointed shall report to those legislative committees, to the select committee, stating the reason why the token is not being issued and perhaps next steps the legislature can take to make it possible to make the issuance. And then the last two sections after that are just related to the rules again, that the commission is specifically authorized to promulgate rules, and that there is $500,000 from the general fund that has been appropriated for the purposes of this act. So, you're welcome.
Thanks. Are there any questions, commission members?
Just, I guess. The one part there says that you're going to monitor the startup and I guess keep us informed as if we're, stepping over the line of any state or federal law. And kind of want to know what that process in your mind might look at, so we know what that relationship's going to be, so we can, kind of prepare for it.
Thank you, Chairman, Governor, Commissioner, Treasurer. So in the previous section, and I believe it was the Romanet 5, but I forget what page it was on. There was a section that talked about the authority to go out and ask the certain federal agencies, and a general authority to ask federal agencies for advice. I mean, my kind of general thought would be that, and of course it's the discretionary section, it's the discretion of the commission to do so, but if the commission did so, that the Attorney General's office could then look at whatever was received and evaluate based on this statute, based on the advice, or whatever we got back from the federal government, whatever that looked like, and issue some sort of an opinion, or could be oral advice at a later meeting on the subject. If the commission does not do that, then I think we would assess what we have and issue some sort of, again, if you requested a written opinion, we would draft a written opinion. It would go through our regular review process and we could provide that to you. Or if you just wanted oral advice, we could try to do a deep dive and try to look at what there was. But I think my suggestion would be that since you have the authority to reach out, probably try to do that first, and then we can look at what we're kind of the landscape, at least in terms of the federal law. I think that would make sense since you have that specific authorization.
Yeah, Mr. Chairman, I think that the way that it was kind of envisioned here, that we would work cooperatively as much as we can together with the state and the federal, entities, and that would and keep things on, I guess, as a real-time track as possible. So if there's a way that if we needed to tweak this, then it would be well in front of any legislative process so they could work on it. So I'm hoping that it's not going to be confrontational, it's going to be cooperative.
Yes, I would agree. Yeah.
Thank you.
Commissioner, I think that makes good sense.
Thank you, Madam Auditor.
Mr. Chairman, and this may be somewhere in the bill and I've missed it, but my question is, under, just from a very practical standpoint, there's an appropriated amount and expenses to be paid under that. Is that anticipated to be within, what agency would that be in? Is that within the governor's agency, or getting into the weeds a little bit? But I'm just wondering, for example, if there was a request in the future for more money, who is presenting that request? And, payment of these vouchers to commission members, under which agency does this live, I guess, is my question for administrative purposes.
Commissioner Auditor, so the The way that the statute has laid it out there on page 9 at the very bottom, all it says is that the funds have been transferred. Well, I'll just read it. It says there has been transferred $500,000 from the general fund to the Wyoming Stable Token Administration Account for purposes of this act. So it's been transferred to that fund. And then the bill on page, well, the act, I guess, the act on page 7, at the top of page 7, sub C, this is from section 106, actually explains what that account is a little bit. It says the stable token admin account is created, and then it has funds from this received in the account from any source. This appropriation would be such a source, shall be retained, expended, or transferred, continuously appropriated according to the following priority: pay for operational costs of the act, again, retention of savings, remainder into school foundation account. I mean, I assume that none of these particular $500,000 would make it into that last category, and it doesn't lay out precisely the way that this goes about, but it seems to be, and I don't know about necessarily the auditing and funds management part, how it's done here, but it seems to be that the funds have been appropriated to this new entity essentially, and that the commission manages those funds and may use them to pay for the operational costs of the act. Probably, given this the relatively small amount, that's probably what all these funds, I would think that would probably include things like you needed to hire, when you have authority to hire in other sections, to hire financial institution, hire auditors and financial advisors. So I would assume you could use those funds for those things.
So, Mr. Chairman, I mean, it has to live somewhere, but I can maybe ask some internal questions about,
Yeah, and Madam Auditor, Devin, if your testimony basically says that's the account at this point,
Yes.
we would probably have to look at rules that would segregate how those dollars were spent. So that's a good point. Further follow-up? And I'm going to make this a little bit informal. And I see Senator Rothfuss here as well. Senator Rothfuss, do you want to come up, and this is sort of your puppy, so. Did you have any particular comments on this?
Governor and Commissioners, I think the walkthrough was perfect as far as the vision for where the funds would lie. I think the answer that you provided was exactly right, that it's tied to the commission, and with the establishment of a commission, as we have for other commissions, the expectation was that it would be managed in the same way that other commissions ended up having their independent funds managed, where they would be attached to those commissions, where this body, the three of you at this point, would have oversight over those funds, and those two new accounts would be created, the administrative account and the trust account. Both of those would be tied organizationally to it and then bound by the statutory construct.
Okay, thank you, Senator. Further questions just on the bill as it's put forward? Hearing none, I will note that one of the technical aspects of this is, I think, Ms. Anderson, did you want to talk about the FBI background checks and so on?
Certainly, Governor. As Devin mentioned, there are two places in the bill that require a background check for new committee members, and then the staff, the executive director, and any employees have to have a background check. That language is in the statute. The process for that is that language then has to be submitted to the FBI for their approval as to whether they are willing to conduct those background checks. That approval from the FBI can take several months. It was submitted by DCI on the day that the bill was passed, March 21st, or it's signed by the governor. So that process is in place, but don't know how long that will take. And they have been difficult lately, and they have turned down certain statutory language for background checks in the past, and they have had to come back and redo that. So I don't know, this language is not part of our standard background statutes. and is slightly different. So it's kind of uncertain as to what the result will be from the FBI's, their response to that approval request.
Just a technical issue. Yeah, okay. Devin, I think it makes sense to roll over to what the Attorney General's, one of the items was the role of the Attorney General under 2023 session laws, Chapter 185, Section 2. Do you want to just quickly cover that? And then I have a couple of specific questions on that.
Yes, Chairman Governor. So again, this is on page 9. It's about halfway down. It's sub B in section 2. It's fairly short. I'll read most of it rather than just summarize it. It says the Attorney General shall monitor the startup phase of the issuance of stable tokens to ensure it's permissible under federal and state law. If after assessing available legal options, the Attorney General determines issuing the stable token is not permissible under either federal or state law, the Commission shall not issue a stable token, and directors shall provide a report, and that no later than November 1. And then that report is provided to, if that is what happens, for whatever reason, they're not issued, then they provide a report to the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology, stating the reasons for that, and laying forth, putting out recommendations that would allow for issuance in the future. So this is another section where there's a deadline of sorts. I mentioned in sub A here in section 2, there was a deadline to endeavor to issue a stable token by December 31. And here there's a deadline that if for whatever reason it's determined that issuing a stable token is not permissible under federal or state law, then no later than November 1, the report is issued to the the Select Committee that pertains to. And as I mentioned before, in terms of like the process, obviously can't speak for Attorney General Hill herself, but I think as a general kind of statement about the way our office would work is that the commission would make a general request to our office for advice and opinion, and then we would work on that and we would develop that opinion, and whether we wanted it in a written form or a written or oral form or both, we could then present that to the commission.
Thank you. And Devin, that's, a wonderful segue. I think the treasurer brought up, he used the term cooperative, but, counsel is valuable not only for keeping you on the straight and narrow, but also for telling you ways that you can get done what you'd like to get done without violating the straight and narrow. And I do hope, I think that was your point, Treasurer, that, you have sort of a dual, as the Attorney General, you have sort of a dual responsibility in this, because it is quite clear this is new and different. It's also quite clear that our federal friends may not look as favorably on it as we would like. And so we want to make sure that we meet the letter of the law, but we also want to get this done. And so to whatever degree there's a challenge on that, I hope that we can work through that before we have a finding that this is not possible. Does that seem plausible?
Yes, Chairman Governor, I think ideally, I think the approach would be to, like I mentioned before, since there is a specific authorization to ask, federal, if we call it partners, friends for their advice. If they were to decline to provide that, then of course we could make note of that. If they actually provide something, it doesn't necessarily mean, even if they were to determine no, that wouldn't necessarily mean that that would be our ultimate advice. We would take that into consideration, and I think that would be helpful. And it's one reason I would suggest we might as well ask for it, right? Even if they declined to provide it, we could still take note of that. And if they did provide something, and even if they said no, we could use that as the basis for our ultimate determination, whether or not we agreed with them, or, equally possible that we disagreed with them. Knowing what their position is would be helpful.
I think that's true. I guess in our experience with speedies and where we are in that process now, I don't want them to be the Lucy to our Charlie Brown on this. So anyway, speaking of that, and I'll probably get rid of the preliminaries here just quickly. The other issue that I'm sure will come up is that we do have expertise in the state, and expertise that may want to avail itself of the opportunities set here. I think it would be sort of brain dead of us if we didn't take advantage of some of that expertise. But obviously there are perils of conflicts that come from that. So at the outset, I just wanted to, if you could opine briefly on sort of what Wyoming conflict law is, and if there are any particular circumstances that you think might be problematic. So, and we can explore this from time to time so that we make sure that the community at large that is very much supportive of this effort and know that we're all working on the same path.
Yes, Chairman Governor, I mean, so it's a general principle, you know, as boards generally, you're precluded from, if you have a particular pecuniary interest in an item that's coming before you. So if, you know, if you as the current members or the four appointed members that ultimately, if, you know, there's a particular financial investment that you have in whatever, you know, in the stable token for whatever reason, that would be problematic. Generally speaking, beyond that, and then of course it also covers for, you know, not nepotism precisely, although that is covered, but more the sort of relationships that would fall under kind of a nepotism thing, that of, you know, spouse, children, close relatives of that nature. But beyond the mere kind of financial conflicts of interest, I think generally speaking, as long as, you know, if a person was to provide advice, whether to this commission or, you know, whether they provided it to our office, I mean, it wouldn't necessarily mean that we would take whatever position, as long as whoever it was upfront about any sort of financial interest they have. I don't think anything would preclude them from providing that advice. I think it would only be problematic if they were to conceal, you know, if they presented themselves as a disinterested party when they in fact had some sort of a financial interest or relationship interest with some party or something, then I think it would potentially be problematic. But as long as the person was upfront, stated that, you know, I am invested in X, Y, Z thing, this will benefit me, but this is my opinion. I mean, that may make it less reliable in terms of we wouldn't want to pin everything on the opinion of, you know, a person who has a direct financial interest, but it wouldn't mean that their position should be discounted. It just may make it less valuable in some ways, and by itself, right? That may, if that makes sense, they could still cumulatively be useful and might be useful as a starting point.
I appreciate that. And members of the commission, just one last point on that track. Devin, I wonder if it would be possible for you or the Attorney General's office to kind of, and I know this is probably a little bit outside of the regular bounds, but if you could provide some sort of guide, because, you know, we have perhaps some domiciled enterprises, perhaps some individuals that have particular expertise or access to types of technology, and we'd hate to have them excluded, you know, from participating inadvertently, if that makes sense. So I don't know if that's a possibility for you to help sort of develop, and it can be a work in progress. Let me make that clear. I don't look for a compendium, simply because there's a lot of work to be done here. The expertise is mostly here in Wyoming or around the world, but probably interested in working in Wyoming. We want to make sure people have access and also help develop, if that makes sense.
Yes, Chairman Governor, that makes sense. And I certainly, like, again, I can't speak for Attorney General Hill on what he would want in terms of process. I don't think there would be any, you know, I mean, if a person wanted to provide, particularly in the technical assistance, I don't think we can, you know, have any sort of, I can't think quite the word, claim to having massive technical expertise in, you know, the world of stable tokens or virtual cryptocurrencies generally. So if personally, if that sort of information would be particularly useful, whether it's just pointing in the right direction or kind of a detailed, maybe even a layman's kind of explanation of some of these things would make it, that sort of explanation have there. And as for any sort of, if they have legal opinions, although I can't speak for her or even necessarily myself, depending on what they look like. I don't think we would discount them or refuse anybody if they were to provide them to our office. I think we would, consider them and look at them whether or not we referenced them or not.
Okay, thank you.
Just to kind of get a practical, I guess, explanation of that. I mean, we've got a lot of registered lobbyists that the state does business with. I think practically every oil company has a registered lobbyist, and practically every oil company that walks in the door drills in Wyoming. So, I'm assuming that there's a lot of folks out there that very well, audience are registered lobbyists, and that I don't believe that would preclude them from offering either their expertise or their judgment or their advice would preclude them from being able to contract with the state in this manner. But we do need to figure out where the bright line is. And I think that's something that, that definitely is in any personal gain that anybody on a commission would have. And I think the people that we hire with the commissioners need to have a good education about, where the bright line is and where we feel the bright line is in our governmental policies. So, I guess what I'm saying is that we've been down this road and rodeo a good number of years in the state, and I think that we've been able to make sure that we've been accommodative to people without letting them accommodate us too much.
Thank you, Mr. Treasurer, for the comments. Auditor.
And Mr. Chairman, I do think even just very basic, I think there's some questions in some situations that are far more gray, but I think even some good guidance and sort of bright lines on, for example, if you are appointed one of these subject matter experts, can you purchase Wyoming stable tokens or not? And so that would be, I think, helpful to know up front for members of the commission and potential experts that we name.
Correct. Thank you.
The auditor did bring up something there as far as the, I guess, availability of purchase. Is this going to be open to anybody to purchase, or are there going to be restrictions on purchases?
These are some of the questions we're going to try to get to.
That's the interesting thing.
Today.
I guess I look at it is that if we're going to be, and this came up within, I guess, the LLC combination or conversation about know your customer. And what was brought up is that every U.S. bank has to know their customer. And so if we had something that just frankly said that, yeah, you can buy a stable token with, through a U.S. bank with U.S. dollars, then we could be assured that somewhere in the line that the customer was known who they were, and that they weren't an oligarch or they weren't something else, or they weren't using the stable token for blackmail or something else. So that's something that you could cross that bridge, I think, relatively easily just by putting that restriction in. But, it's just, I think we're getting to the whiteboard stage now, Mr. Chairman.
No, I know. Yeah. Essentially, and I'm going to open it up a little bit to the floor here. What I wanted to do is just kind of lay out the framework. What's the bill? What is the role of the Attorney General? Some considerations beyond that, I think, gaps, and I think there's perhaps some rulemaking. So if there's comment at this point on those matters generally, please step forward if you would like. Charles, I see you rustling around. And then just Charles, while you're getting settled from this, then we'll kind of start to work into who are the people we need for the commission expertise, what are the areas that we need, and we'll kind of proceed from there. But please, Charles.
Sure. Chairman, Governor, members of the commission, I came down from Wheatland today, a bison rancher up there. I'm also a cryptocurrency CEO, so it's a nice mixture of things. Good to see a senator as well. So we were very curious. My company, IOHK, we're based here in Wyoming. We're a Wyoming-based C corporation. We have about 700 employees, contractors, and affiliates all throughout the world. And we build cryptocurrencies and blockchains for a living. We created Cardano. I was a founder of Ethereum, and I've been in the industry for about 10 years. So I've been all around the world, from Switzerland to Abu Dhabi. And we have quite a bit of experience internally dealing with the various regulatory frameworks about issuing cryptocurrencies as well as issuing stablecoins. There are a lot of questions that we had when we were internally looking at the bill. For example, the nature of how custodianship is going to work, how issuance is going to work, the audit and oversight, the compliance side of the house, and what standards one wants to adhere to, if there was to be retail participation or not with this asset, and also what were the financial intentions. The commission may be unaware of the totality of the market, but the stablecoin industry, just on the US dollar side, is over $100 billion of assets. And Tether, which is the largest player, which is about 80 billion, makes as a company about 2.4 billion a year. I think Wyoming's budget last year was 5.6 billion. So this is a pretty substantial affair as an industry. And at the moment, there's no one as credible as the state of Wyoming to issue some things. That said, there's a lot of regulatory uncertainty, especially at the federal level. And given that the bill wants to get something in market, or at least something issued prior to the end of the year, my recommendation is to find a way to issue with gates, where it gets issued to maybe a private trust company with no retail participation. There wouldn't be any federal problem at that point because there's no cross-border commerce. There's no retail customers touching it, so you don't really have to worry too much about the security side or the commodity side or what the SEC or CFTC thinks. And just have gates that inhibit one's ability to do retail distribution until suitability guidelines are in place and a regulatory framework is in place. In terms of the broader environment of the cryptocurrency environment here in the state, over the past few years, thanks to great legislation passed and enacted, there are some amazing cryptocurrency companies here, like Custodia, like Kraken. The University of Wyoming is one of the world's centers of excellence for cryptocurrency research, right up there with Stanford and CMU and other international institutions. And there's even a representative here from the University of Wyoming who runs the blockchain lab, Steve Lupin. So there's a lot of wonderful people here. And if this is going to get done, my view is that it needs to be done as a public-private partnership with a coalition of entities that are floating around here, both in the state and abroad, to build it in stages. For our part, my company is here to serve, and I know a lot of other people are as well. But I did have a question about the subject matter experts. As you mentioned, Mr. Treasurer, it's not clear to me, if one was to serve as an SME, what would the RFP process look like, and would there need to be a recusal? For example, if there was a subject matter expert on the commission, could that subject matter expert's company also bid to build a stablecoin, as a hypothetical example? We're kind of in that area where we build cryptocurrencies for a living. 500,000 is not a lot to do this with. Usually the budgets are in the 7 to 8 figures to issue it. But if we participate in the RFP process, would we have to choose one side or the other, the SME side or the RFP side? Does this make sense?
Yeah. You said that you think that we shouldn't jump into the retail side. I'm wondering how many other coins out there are already in the retail side, and why would we prohibit ourselves from entering that?
My recommendation is not to immediately do it until the state is prepared to do it. Employees have to be hired, policies have to be written, and you also have to make a decision of where you're going to attract liquidity. So stable coins in our industry are global items. They trade 24 hours a day, 7 days a week in every country in the world. And the problem is that even if you do KYC and AML at the primary issuance, meaning the first initial distribution, the secondary market in a pure cryptocurrency sense can trade anywhere. So this creates very unique regulatory and tax implications, both at the federal and state level. So it's probably good to fully understand what those are, and I think it's a bit dubious by December that the state will be in a position to fully appreciate that. So it's not my recommendation to the commission to not issue it to retail. It's just to do it first to a holding entity until there's a framework in place. And if that's in place prior to December, then go retail. But if it's not, then give yourself the time to be able to figure that out.
So the framework that you're talking about is just, could you, I guess, elaborate a little bit as far as what geographical areas that framework would have to, I guess, be in and operational, or?
Sure. So first off, what is it as an asset? Is it a currency, a commodity, a security? If you're a currency, you have a constitutional challenge. If you're a security, you can have a retail participation, but there's a lot of very unique challenges, and the majority of cryptocurrency infrastructure would not be fit for purpose. For example, Kraken, which is domiciled here, is an exchange. I have an account. Many people have an account. They don't trade securities, they trade cryptocurrencies. They need to enter the broker-dealer infrastructure to trade securities. So there's a lot of questions about that, just with respect to US participation. But then going beyond the United States, there's also now international regulatory frameworks like the FATF, OFAC compliance, these types of things that have to be accounted for. For example, what do we do if these tokens end up in the hands of a country that's sanctioned, like Russia or Iran? So what party is responsible for freezing accounts, reversing accounts, these types of things? And these are technical questions as much as they are regulatory questions. And the problem with cryptocurrency protocols is they're very stupid. They only do exactly what you tell them to do, and they don't have discretion. You have to program those capabilities in. So there's probably going to be a long RFP process to get all the acceptance criteria completely figured out, and also to figure out what that software lifecycle looks like and how one is going to upgrade the system to accommodate changing regulation. There's also going to be a lot of activity at the federal level over the next 24 months, with both the judicial branch making decisions with the Ripple case and the Coinbase case, which will be very transformative to asset interpretation, and very likely legislation that will be passed that will start creating new categories. Like Senator Lummis, for example, introduced the Financial Innovation Act, and it created a whole new asset category called an auxiliary asset that would have a different interpretation. So there's just a lot of these things that interface with international law. The MiCA framework in the European Union, for example, is starting to develop rulemaking for how to treat cryptocurrencies. There is a section on stablecoins, and I'd highly encourage the Commission to pull that section and read through it to get an understanding of what our neighbors in Europe are doing, just so you can see the concerns and questions they had, as is the GCC, Abu Dhabi and Dubai in particular, are creating bespoke frameworks, as is Singapore. So there's an interoperability of international markets. That's where the opportunities are, and that's how you get to those Tether-style numbers to make the billions of dollars a year. But then there's also a lot of changing federal law that's probably going to occur in the next 24 months. And then there's, of course, what's required to make it work for exchanges like Coinbase and Kraken and others who provide the retail access points.
Sounds like we need 3 or 4 subject matter attorneys on our payroll rather than such other subject matter
Yeah.
folks.
Well, and thank you, Mr. Treasurer, and thank you, Mr. Hoskins. Auditor, I think this conversation is just the sort of thing that we need to really sit down with a whiteboard and a small working group. Madam Auditor, Chris, any Senator, any?
Chairman, Governor, I appreciate the insight that Charles brings, and in particular, the idea of issuing a token by the end of the year. That was, to a large degree, and we had the conversation and the internal discussion was, does not mean full implementation. It really means aspiring by that point to have an issuance in some type of a sandbox. And then what does that sandbox look like? So it can be an internal issuance. Basically, that's a good milestone, and that was what was discussed. I think the framework that Charles has laid out of trying to, along the way, build the pieces for the regulatory approach and make sure that we have international compliance, make sure that we have the capacity to engage in the retail market is essential to the success of the Wyoming stable token, but it certainly will take some work. And obviously, as we've discussed, the 500,000 was a jumpstart number, but certainly not sufficient to do all of this work, which is why the revenue off of it will come back to it. We've discussed things like revenue sharing agreements and other things to ensure that any partners we have would have the capacity to bring in sufficient resources from the process itself. The compliance from the regulatory standpoint that is faced by some of industry, I'm hopeful that the state of Wyoming can actually elevate that to some degree and provide support for the industry that's struggling with the federal government. That's one of the visions that we had was, I don't feel like the stakeholders are necessarily getting the appropriate attention that they need and being treated fairly in this space. And hopefully, as the state of Wyoming, and with our standing with regard to securities and with our standing as a sovereign entity of our own, we might be able to elevate some of those issues and hopefully help with some of the concerns that Charles raised. So I appreciate the comments and appreciate, obviously, all of your expertise, experience in this. With regard to the SME versus RFP, I think that is something that your commission needs to work through how that process, and that's intentional, was not put in statute. It was left vague to give you all the responsibility to work that through and come up with an appropriate, hopefully elegant solution for it.
Thanks. Madam Auditor, anything? Okay. Charles, thank you. I think there were several points you made that I think are probably going to be part of further work that we do. And I look forward to engaging with you on this. The question you didn't have answered, which I had really asked Devin a little more vaguely, was to what degree does a person in participating in this remove themselves from being able to be a part of its launch, and that's the part I want to put a fine point on, because you mentioned both Kraken and Custodia, two pioneering and courageous outfits that decided to stake their claim here in Wyoming, and we certainly don't want to curtail their ability to participate in this. So, anything else you'd like to say? Or, I mean, I guess I anticipate we're going to have these 4 people that we want to talk about adding, and so we'll talk about that in a second. Go ahead.
Sure. Just one final comment. The world is very excited about Wyoming, and I was recently actually in Abu Dhabi. I was at the ambassador of Barbados to Abu Dhabi's state, talking to the sovereign wealth funds there, as well as some of the leadership of the country. And as they were discussing the regulatory framework, they actually brought up Wyoming. Generally speaking, Abu Dhabi doesn't discuss Wyoming very much, and when they do, it's about oil and gas. It's not about cryptocurrency legislation. So this state has achieved a tremendous reputation throughout the world as an innovator and pioneer, and one that was willing to take a risk to embrace new industry. And while this is an incredibly exciting piece of legislation in that it could extend the dollar into the crypto space in ways that it should be, it is also a very risky piece of legislation if it's mishandled, and there's many challenges to it. So our industry as a whole has a unified incentive to ensure that this is a success. And so we'll do our part, and I hope the industry can work together and provide as much assistance as possible, both on the regulatory and technical side, to get this where it needs to be. We're here to help.
Thanks very much, Charles. David, please, if you want to come up, and then I'll see you next.
Thank you, Mr. Chairman. My apologies. Thank you, Mr. Chairman, Governor. I appreciate the opportunity to speak. I'm David Pope. I'm a certified public accountant, licensed here in Wyoming, and I've been an accountant for 35 years. I have had my own firm here in Wyoming for 28 years, and I was one of the founding members of the Wyoming Blockchain Coalition. I also sat on in the first year on the Wyoming Legislative Blockchain Task Force, and I think Senator Rothfuss will attest to the fact that I have remained involved, and this is honestly one of the first ideas that really struck me, the whole thought of the state initiating its own cryptocurrency. This is different. This is not a cryptocurrency, but this is the offshoot, I believe, of some of those initial discussions that we all had. And it is something fascinating to me. But the operational auditor side of me likes to discuss a framework of how this is going to happen. And just in my notes, I see 5 areas that need to be addressed with timelines and production responsibilities created and all of that. You know, you have the technology and production side. You have the marketing side when we go out and make a market for this token. You have the accounting and auditing side, which I think, of course, is the most important, but that's just me. You have the compliance and AML side, which we've discussed a little bit about here. And then you have an odd little side that the Treasurer's Office will need to deal with in the investing side, because I see that as one of the greater risks in this right now, even though we have defined it to treasuries. This is still a matter where in a rising interest rate environment, the treasuries that I buy today are worth less tomorrow. And so in my mind, that's a risk that we will have to overcome in the investing side through that additional savings part. I think we will initially have to overbuy treasuries in order to hedge against that risk. But it is something that has to be considered. And I also know that the legislation de-risks the general fund completely. However, in any situation where a token is redeemed for less than $1, that's the death of the token at that point. And so that's why I think that is one of the major items that we have to look at. The accounting and auditing side, which is what I guess I'm most qualified to discuss. There are firms out there now that will do a continuous audit of the fund, both the backing fund and the outstanding tokens. Armanino did that. They discontinued that and split that side of their operation off into, I believe it's called Network Firm. But one of the things they will look at will be that market value of the backing funds, not just the dollar-denominated value of those funds. On that side of it as well, it is just something that we need to plan for, because in truth, what this is, and for compliance purposes, and this is a debt that the state is taking on, a very specialized debt, but it is a form of debt in a form that states have not engaged in prior to this. But it is still a debt, and so a lot of the compliance that we that we look at will be centered around how do we comply with the sale of that debt to the either the public or to institutions or however that's managed.
Thank you, David. Go ahead, Treasurer.
I think we can manage, you know, the duration problem with what's coming into focus now in some of these banks that have gone broke. We simply just, what we've done with our ladder strategy is buy discounted bonds and then rolled them out and did it every year. You just move that down to where you're actually doing it every day. And you buy a 90-day treasury that's gonna, you know, mature in 5 days. So if you, or mature the next day, you know, as long as you do it at a discount and move it through there, or you just hold cash, which essentially is notes, treasury notes. They're you know, they're paper notes, and cash is over 5% now. So, you know, there's a way to go ahead and make sure as you implement it, if you don't grow too fast, then you'll always have enough running through and coming back, you know, on that time schedule to where you basically, unless you have a run on every single cent that you have out there, you know, you can pretty much manage that type of thing. It's unfortunate that our banks weren't doing it that way, and they got a little bit over their skis and got greedy, I think, in certain circumstances. But I think that's the one thing that our shop probably does the best is managing our fixed income. We've got some folks there that understand duration, they understand the risk, and we have a BlackRock risk. It's a program called Aladdin, and that will, you know, keep you track of pretty much everything that's going in the treasury market, and it allows you to make hypothetical trades and see what that would happen, and then go ahead and stress test that, so you know that what will happen in times of stress. So I feel very confident that if we put the parameters on it, so we know that what we have to do, that we're not going to end up like a bank, and we're not going to be out there, you know, like some of these stable coins before, going out and trying to get in the high yield market and ending up with garbage.
And thank you, Mr. Treasurer. I guess, you know, just in the interest of time, I want to make sure we don't go down. This is really at a very high level today. And Mr. Pope, thank you very much for your thoughts. I don't know if there's other questions for Mr. Pope. I'm going to put Steve on the hot seat here in a second. Yep, you. David, thank you. And if you want to respond, please feel free. What I want to do is I'm trying to build what the 4 members that we can appoint to this commission are. And at present, I'm seeing, just for the other members of this board, and we'll certainly talk about it, it would be good to have legal expertise. It'd be good to have audit. And it's not the normal audit capacity. It is that, but it's also the ability to read smart contracts and code them and understand the code. It is perhaps to some degree custody, which I would also say is, you know, putting them on exchanges. To Charles's point in marketing, it would be there. And then I think the technical expertise. Those are the 4 that I think I've identified so far, but there may be others. Steve, you know, the reason I was going to put you on the hot seat, if you're willing to do it, and you can say no, is simply that the university has some ability in a kind of an unaffiliated way to be able to bring some expertise to bear on aspects or problems that we need to solve. Okay. That was just my notice to you that we're going to lean on you for that. Questions?
One more
Mr.
thought.
Pope.
Yes, just one more thought on this. And remember, yes, you can hedge against this risk. You can use those techniques that you discussed, and absolutely they will work. But in a continual audit environment where it is real time, all the time, as soon as that market value drops below $1 for the fund, $1 per token for the fund, then that is significant in this atmosphere. So wanted to leave you with that, and thank you very much for the opportunity to talk.
And Mr. Pope, that is what you just talked about is my biggest concern, because the
Right.
contagion goes to, it goes across Wyoming, not just the crypto, not just the, our speedy opportunities, but it also goes to our banking sector as well, which is, I think, why we want to be as meticulous as we can in this.
Thank you.
Thank you. Thanks. Further comments, questions? Madam Auditor.
Mr. Chairman, did you have any particular, so big picture, of course, we are needing some legal advice, that is clear. It also seems that we wouldn't wait to sort of start some of these other sort of parallel tracks, why we look for and receive that advice, because if we wait till we get it, then we're past, we're a ways down the road. I guess, do you envision a certain procedure for potentially filling these spots for subject matter experts? Would that be, folks expressing interest, or, us just saying, hey, you over there, which, has happened? Just I just imagine some folks are wondering.
Yeah, what I envision, and it's certainly up to the commission to talk about this, what I envision is that, and let me make it clear on the legal piece, it is not to second guess what the Attorney General brings. It is to find people with particular expertise, perhaps in international law and other aspects of the regulatory framework, which I think would be good to bring on board. But my sense is an expression of interest is certainly valuable. I think we don't want to wait for another commission meeting, so I think between the three of us, if we can, kind of work that out and on an as-needed basis, we'd have to, because this is a public commission, we would have to notice it and so on and so forth, but I don't want to slow things down. I do want, and I think we have been able to work expeditiously in the past, but as we get a group of names for these positions, that we then sit down and kind of sort through them, if that makes sense to both of you, and maybe have some communication. So for the people watching and for those of you that have connections in the community, to the degree that you want to express a general outward push that these are people we're interested in having, please give us names. Otherwise, we're going to go draft you.
And Mr. Chairman, just real quickly, and knowing that we don't have to subscribe to these exactly, but your sort of 4 buckets were legal, accounting audit, technical, and what was the fourth one?
I was talking about custody.
Custody.
And I really, I'm not talking so much about the custody of the assets that are going to back the stable token, but custody of the, and that's the whole sort of
Okay.
ecosystem, from whether it's a trust to whether we're going to put it on exchange, how many exchanges, what are the conditions that we're going to do it on. So.
Yeah,
Mr. Treasurer.
Yeah, Mr. Chair, and I'm looking at this, I think, I think we actually need more members, and I know that the way I look at mine here is that, it's me or my designee, and I would probably look at a designee and be an ex officio in the sidelines, just trying to put my 2 cents in after it, and so I can see I'd like to have more of a to the extent that we could have more of around the kitchen table, around the whiteboard type of an operation, because I could see where we may be able to get 2 or 3 experts on one subject matter that might be able to get together and come up with something better than one. And so that's kind of like a mini board of boards on different areas. So I'm not sure it would get more people involved, whether or not we'd come up with the right way to go about this. But I think that the timeline, I think, is really important. I think the timeline is important for us to get something out there, just in case the federal government comes in, and often they'll grandfather somebody for one reason or another. And if we're the only state with a stable token, I hear Texas is doing one with gold now, or thinking about it or contemplating it, which we've never been able to figure out how to make any money on gold. So that could go underwater real quick. So we don't have much fear on that, I don't believe. But yeah, if the more people we can get in this room, and there's a lot of people that I know aren't in the room that we need to, I think, to get involved.
And yeah, Mr. Treasurer, I appreciate that, and I tend to agree. I do think that the larger the committee gets, the less it gets done. And so, my particular view on this is that we're talking about a lot of coffee clatches, a lot of groups getting together and maybe reporting up. So, Senator.
Thank you, Governor. And Governor, that was our intent also with 7 is that workable size where you can still get some work done, but you have a diversity of views, and that was the intent there. With everything that we've done on the select committee, including the stable token, we've assembled working group after working group on special topics and then just sat through those Zoom meetings over and over again. The community of stakeholders is amazing. If you need 20 people on a Zoom call on a specific technical topic in this space, you'll get 20 people on the Zoom call, and every last one of them will provide valuable information. So there will be no shortage of willing, competent, amazing participants available to you. But at the end of the day, you need about 7 people to then make the call when there's differing interests. So I think your buckets are exactly right, though, just making sure you've got a diversity of expertise, that you've got sufficient competence to understand what the technical experts are telling you, or whichever groups you put together. And I appreciate that thoughtfulness.
Thank you, Senator. Let's pivot a little bit to timeline. Obviously in statute, Devin, I think we have the December 31st and the November 1st timelines.
Yes, Chairman Governor. They're both there in section 2, but yes, there's the December one to issue endeavor to have issued a stable token, and then the November one, if you're unable to issue a stable token, that there's a deadline to provide a report to the select committee.
And just to be clear, I think we're supposed to, by November 1, indicate whether we are able to proceed to issuance.
Yes, and that would be the subject of that report. I don't necessarily take from the way that it's written that if we would determine that issuance is fine, that you would necessarily have a deadline on November 1. I read it as being if you were determined that you cannot,
Right.
in that case, then you have a deadline November 1.
Perfect. So those 2 dates are on the calendar. Yes, Senator.
And very briefly, that November 1st really was just a timeline for if there's a problem, that's going to be theoretically sufficient time for legislature to take action, if that would be helpful.
Yeah, appreciate that, Senator. Thank you. So we have a kitty of 500 grand. We have a consultant that we can hire. And then also an executive director. Those two. So it seems to me, finishing out the commission, hiring a consultant probably can be done somewhat more early in the process. And then an executive director, those things that should all be done in a relatively short order. So what's your thoughts on that? You know, in some ways, I would not mind looking at, I'm not sure exactly what we'd have the consultant do, but I would like to sort of consider what that consultant is going to bring to the table if we are going to hire one, first and foremost. And that's really, you know, what are the things you need and how are you going to approach this? Maybe that can be done by the community and save us some dollars. An executive director probably is a little bit longer process, and we shouldn't delay ourselves too long in looking for that individual. So I'm going to recommend that we probably have somebody in queue not later than July 1st. Does that make sense?
Yeah, I think, Mr. Chairman, one of the things that I know I always do in my shop is I try to figure out what skills the person has to have, and and develop a test to make sure that they actually have them, and I'm just not getting bullshitted, excuse my language. So, you know, I think that's the first thing for me is to define what we want the person to actually accomplish, and then try to do some kind of a skill test to make sure that if they walk in the door that they can actually do it. So that I think if there's you know, some consultants that would actually help us on that as far as in that hiring and in that area, I think that would be good. That way we know we're not going down a road to nowhere.
Okay, Madam Auditor.
Well, Mr. Chairman, and I know that the community is flexible and can turn on a dime perhaps more than other traditional industries, but the timing will be a little awkward too, where we may be offering someone a job that we may not have the final legal answers on too. So,
No, I appreciate that, and we don't know what the FBI determination on background check is going to be or anything
yes, so
else.
just knowing that could be, yes, we'd like you to come work for us, but it may be illegal and you can't. Otherwise, you're good. And also, and just knowing that the funding right at the moment is not endless, right? Or not continue, not yet.
Right.
Not yet in a standard budget anywhere.
Yeah, and I appreciate that. I also think we've got to get started. So is the 1st of July, I'm trying to look at what the process is on the other side of that. You know, you're going to come on the 1st of July, first month's going to be trying to figure out where the bathroom is. Second month is going to be trying to figure out how to deal with, you know, the circumstances that we have. The third month is probably just going to be operationally making things work, and then we have to report to the committee. The fifth month, hopefully, you get things put in place, and the 6th month, you're up and running is hopefully where that sits. Pretty damned ambitious. Charles earlier today said for the government to outdo private industry, that would be a remarkable feat. So, but I think that's the timeline we have before us. Does that seem reasonable? That's not the right question. Does that seem doable?
Well, I think it has to be doable. We have those timelines. I think, Governor, they're going to have to be met. So,
Okay.
you guys want to hang around a while today?
Okay. All right. What I'm trying to figure out now is sort of what next steps are. I think we have to get various people that are willing to serve on the committee. I think you know, there have been a couple of people here, David and Charles, that have some expertise. Steve, I don't know if you'd like to participate, but I wouldn't mind if you gave us an outline, or if anyone else has not addressed us but has an interest, give us an outline of what you think the questions our consultant ought to ask or ought to be able to try to work towards an answer on. That would be helpful, I think, speaking for myself, to all of us up here. Is that something that we can ask of you all? I get a yes. Fantastic. When is that possible to do within the next week or week and a half, 2 weeks, something like that? Doesn't have to be a white paper. It just would be nice to have coherent thoughts on the questions that they, and you know, David, you started talking about that. Charles, you did as well. Steve, I know you and I have had these conversations in the past. Others may have that as well. And just as an outline of what we ought to be asking the consultant to do, and perhaps if you want to tag on, what are the questions, to the good treasurer's point, what are the questions that we would want an executive director to be able to, that talents he would bring or she would bring, and the particular expertise that they should have.
Yeah, Mr. Chairman, there's a person back there. I don't recall his name, but he stood up to testify, but.
Oh, I'm sorry, yes. Yeah, I'm sorry, you're behind Devin.
There we go. Green light. Mr. Governor, Mr. Treasurer, Madam Auditor, Senator Rothfuss. Used to seeing you here, Senator Rothfuss, when we talk about the little engine that could. That's what we've called the Wyoming Stable Token. My name is Sean Murphy. I've been an investor and consultant in the crypto space for some time. I was on a contract to hire job with Bison Blockchain. We were building the largest Bitcoin mine in Wyoming until there was a hostile takeover by a Chinese company. So I don't represent anyone now. I'm here just speaking on my own behalf. And it's been a lot of advocacy to get to this point with this bill. I've been one of the main advocates for it, but Mr. Governor, I must say, I just appreciate your discretion and concerns that you've had with this. It is a tricky situation, all of this, federally speaking, states' rights, but there are so many of us that appreciate what you have done, letting this pass and letting us take a good look at this. I believe it's an important states' rights discussion that we need to have. And there has been a lot of great legislation that has happened to bring us to this point. So thank you very much from many people that see this as really an important conversation. Even if we don't ever endeavor and issue the only stable token ever, we've done a great job planting that flag for states' rights and defending what I think will become a real issue with central bank digital currency. So thank you very much. My one comment from what I heard today was about conflicts of interest and with these other board members. And I think to maybe distill what Charles was saying is, I did a very long diligence process looking at potential developers for this over a year ago. And the result of all of that diligence and research was really that IOHK would be the best developer for this. I could enumerate all the reasons why I think they would be the best candidate for that. And I still believe that they would be, for many reasons. But I think the question that Charles was asking is, could he also be on the board if his company, IOHK, was doing the development? And I think that's the question for the three of you to consider, and the other board members. Is that a conflict of interest? I'll leave you with one thought with that, was with Secretary Gensler from the SEC. He was testifying before Congress a couple of weeks ago, and they asked him if he had any cryptocurrency. You know, Secretary Gensler, do you own any Bitcoin? Do you own any Ethereum? And he had never used any Bitcoin. He had never transacted any Ethereum. He had zero experience in this thing that his entire agency was regulating. And that struck a lot of congressmen and women as very peculiar, that here we have this secretary who is supposed to be overseeing these regulations, but no knowledge, working knowledge of it. I think with Charles, that's very different. He has a great working knowledge and the expertise on both sides. So I want to stand by that thought that IOHK would be great. Also, Custodia would be the natural fit as the speedy. But with that, I get that there are the risks and concerns that have been expressed that you shared in your letters that are still on the table. So I think these need to continue to be looked at with a lot of concern, but I am just very proud that we are here and all the work that has been done. Thank you.
Thanks, Sean. Very nice testimony on your part, and I think you also raise a really important issue, is that this is not antagonistic to the traditional banking system. It can be a terrific adjunct to the traditional banking system. But it is a different form of settlement, and one that the state can pioneer, that will be perhaps incredibly important, not only for just the state and states' rights, but also for financial stability going forward. So,
Very well said, Mr. Governor. Far better than anyone else would say that, yes.
thanks.
Thank you.
All right. Next, other comments? Yes, sir, please.
Thank you, Governor. Okay, great. My name is Scott Muller, Governor. I'm one of the organizers of the American Crypto Fed DAO. We are the first DAO that was legally recognized in Wyoming, July 1st, 2021. Very excited to hear the progress that's happening in this first session. And I do want to and I also really appreciate the focus on the whiteboarding and special interest groups, because I think that really is going to be the next step that we're going to need to take. One thing I do want to focus on, though, is the use case for the token, and that use case being for retail, because I think we may have a different perception of what retail is. When I speak about retail, I talk about using the Wyoming stable token for real world transactions. So using it at a retailer, so a Starbucks, a Walmart, those type of retailers. So we've been working with the Merchant Advisory Group. That's a consortium of America's largest retailers. Together, I think in 2019, they had $4.8 trillion worth of transactions. So over 60% of the credit cards and debit card spend in the United States went through these retailers. So, and that's just a contrast against the current perception of the stable token market today, which is at $100 billion. So when we're envisioning what the use is for Wyoming stable token, it's for that far greater reservoir of retail transactions in the U.S. That being said, everything that's been talked about in terms of who should the commissioners be, they all make sense. Okay, you need to have people that understand custody, that understand all the technical natures of this, but don't lose what is the final use case of this. And that being said, we also see that the Wyoming stable token can be on multiple chains. So I envision it's going to be on a Cardano chain, Ethereum, the American Crypto Fed blockchain is a EOS-based chain. So we're not on the EOS mainnet. It's a sister net, but it's our own private chain. But we would envision the Wyoming stable token being on that chain as well. Joe, do you have any comments you'd like to make?
Yes, so our blockchain will be run by the major merchant. So we need, well, at the starting point, we need 21 major merchant so that our chain can be fully decentralized. So that is a protocol. So if we have 21 major merchant, and the volume will be big. So we hope the commission will consider we can directly to allow those merchants to purchase Wyoming stable token directly from the commission and redeem directly with the commission and not through the crypto market, which will definitely affect the fluctuation of the market. So this is a big play, and we anticipate to engage many of those major merchants. Today, when we talk with the MAG advisory, merchant advisory group, we know them for a long time, more than 10 years. So a lot of them have a problem with the current credit card, or debit card, and the cost is high, the speed is slow. So there are many, many issues. They are looking at Wyoming stable tokens can do something together with the commission. So for you to understand where we are coming from, probably Scott can give a little bit of history about where we're coming from. So Scott, can you do a little bit about that?
Yeah, sure. So I give you a little bit of background about MShift, which is the company that is the single member of the DAO. Okay, so MShift I founded back in 1999. It is a mobile banking company. We've had some of the, so providing, when you think you're logging into your bank on your phone and you think you're talking to your bank, many times you're talking to MShift servers, which are then securely talking to the bank on your behalf. So for mobile deposit, transferring funds, all that. So we've done everyone from the tiniest community banks and credit unions, Meridian Trust here in Cheyenne was MShift, to 2 of the 5 largest banks in the United States. So our history is millions upon millions of secure financial transactions, managing that, okay, before blockchain even existed. That's what we did. I met the MAG, or the Merchant Advisory Group, at their foundation. Back in 2009, MShift was invited to become a member of the Mobile Payments Industry Work Group, which was put together by the Boston and Atlanta Federal Reserve offices. So Boston is in charge of retail payments, Atlanta is ACH. So they put together a group of the stakeholders in this new emerging mobile payments industry. PayPal was selected, Apple was selected. We were selected as a technology provider because we were one of the first people to come up with mobile deposit. For the AT&T, Verizon, who else? All the credit card guys, but then the merchants. So I was introduced to Walmart through there. The MAG got formed. Kroger was there. So for years, we've been talking to the merchants about lowering the cost of payment. That's their whole purpose. So the introduction was through the Boston Atlanta Fed, and it was to lower the cost of payment. And that's how we know these guys.
Yeah, so when we think Wyoming has done a lot of pioneer things. So we had an idea. We suggest that to, at that moment, that group, the Fed leadership, to invite Senator Russ Fields and Senator Tyler, and they were welcome in there, and they have a huge discussion over there. So since then, we tried exploring how to take advantage of the technology of crypto, blockchain, all of this. So Wyoming stable token is a huge, big starting point for them to exploring this path, because Wyoming stable token represent $1 to $1 and stable, so they don't need to solve a lot of problem in accounting. And also there are a lot of legal issues. Probably, I believe, Wyoming stable token, if they accept the Wyoming stable token, will solve a lot of real problems. Their legal department and have all concern about a lot of legal issues surrounding with other stable tokens. Wyoming stable tokens can solve that problem. So we really hope this can become a starting point to bring those MAC group, they represented 60% credit card transactions, to this commission and have if we can establish solid communication channel, then I think we will have great future.
And just if I can add on to what Joe's saying there, I don't think that you're going to need to have a MAG representative as one of the commissioners, but it is that communication channel. Please don't lose sight of how large this retail market truly is. Okay, because we are at a very pivotal point in our society, in our economy. Okay, and I know all these MAG guys, they're gonna use FedNow. They will use the CBDC. They'll have to use it. Okay, but this is such a wonderful alternative. Okay, this is the antithesis of a CBDC. Okay, admittedly, it's being issued by a state, but that's not the intent. Okay, it's to issue something that can be used freely in electronic format. So yes, so just we want to keep the line open of communication between the state and the merchants, because it can create revenue streams like Wyoming's never dreamed.
Thank you both. Please go ahead.
Yeah, there is one problem is when we discuss with a merchant, large merchant, they say when they accept Wyoming stable token paid by their consumer, do they need to convert partial of that back to US dollar to pay the Wyoming state sales and use tax? So if it is very convenient for those larger merchants when they receive Wyoming stable token, and they can pay the sales and use tax directly using Wyoming stable tokens. So this is a very reasonable request. And also to let all those big merchants to share their issues, their problems. The state itself is big merchant accepting payment for a lot of government services, cities, government, situations of public schools. So will all those entities, government entities, accept Wyoming stable tokens? Through that process, they can share the same problems, including point of sales, a lot of that issues. So will the Wyoming stable token can be spent by those government entities as those big merchants? The MAG merchant, I think they have a lot of operations in Wyoming state. So they're big chains, national chains. So all those can be discussed, and if we can have good communication channels, we can lay out all those issues and we can solve them one by one.
Great, thank you. And I think, Senator, you have a very full agenda. Auditor.
Mr. Chairman, a quick question for Mr. Kenny. I assume, I hate to be the fun police. This commission and its operations would be subject to procurement, standard state procurement laws, would it not?
Yes, Madam Auditor, Commissioner. Unless there's an exception from state procurement law, which there isn't one here, then any agency is subject to it. So yes, you'd be subject to, just like you're subject to the Public Records and Public Meetings Act, like that.
So, Mr. Chairman, where I think I was getting in is it sounds like, going back to your sort of potential first steps of consultant and director, we are working within the boxes that we have to, and so that I'm assuming we need first steps, RFP, job description for those two tracks.
And Madam Auditor, that sort of is my view about soliciting comments about what goes in the RFP, as opposed to us organically doing it, because I think we'd have a much better, we've heard a lot of testimony today that certainly broadened my horizons on this. And then I agree with you, the job description, both of which can be informed by getting those comments in early on. And, Steve, this is going to teach you not to show up. I apologize. You know, simply because I don't know if this venue is the best for sort of workshopping things. You know, it would be nice if we could avail ourselves of some of the facilities, perhaps at the university, to be able to actually sit down in a workroom and have people. Mr. Chairman, Governor, in fact, I just built out a ideation space as part of the Center for Blockchain and Digital Innovation. It would be an honor to host, you know, some discussion. Fantastic. Thank you. Mr. Treasurer.
Yeah, Mr. Chairman, and the reason I asked that retail question is that here a year ago when I was, we couldn't move forward, but I wanted to try to get a jump on it. I did ask some different programmers, and what I asked them to do was give me a something that'll work on an Android or a smartphone, and essentially trade our tokens and dollar for dollar. And the programming cost on that was relatively small. I think it was less than $50,000. And then another person that was going to do the, I think, do the accounting of it, the whole package was less than $100,000 to do that. So, you know, evidently we must have left out some protocols that you were talking about in that analysis. But yeah, I think that the retail, I think, has a very good potential to move forward. And essentially that you know, you can do those exchanges for basis points where credit cards will cost you 2 or 3%. And there's a huge area there where I think that if we wanted to do a test market on that, I think we should at least have that discussion about doing a test market in Wyoming. Because I think if we get over that hump, then we can certainly do things like make sure that all sporting goods purchases are sporting goods purchases.
Thank you, Mr. Treasurer. Well, great. Please come back up.
So in our mind, Wyoming stable token will be used nationwide, not only limited to the state of Wyoming. So there's nothing to limit it, Wyoming stable token only to the state of Wyoming. For those large merchants, they operate nationally, sometimes internationally. So we believe Wyoming stable token can be deployed not only in Wyoming, but also nationwide and internationally. So we see this as a revolution if we have a full support of the state of Wyoming and provide legitimacy to the crypto industry like we are trying to do in the retail. Thank you.
Yeah, thank you. And good point, Madam Auditor.
Mr. Chairman, I do think that maybe one of the questions that we perhaps need to square away is, you know, whether someone who has interest in responding to an RFP from the commission can also serve on the commission. And I'm looking at the language in the bill, and I am happy to have folks disagree with me, but just, you know, only subject matter experts who are free from conflict of interest in performing the duties of the board. One of the duties of the board is to select the consultant and to select the entities, you know, performing these tasks for the commission. And I just look at other commissions and boards that the state has in the operation they do. And I do not believe that someone could serve on the commission and then just step away at the last minute and then respond to the RFP. And again, I'm happy to be maybe corrected or disagreed, but to me, that does not pass muster from a I'm not sure how one would defend that that is not a conflict. And so I'd love to hear other folks' thoughts, but the one thing that I think is very evident today is that we have a very robust community of experts that are able to serve. So I think that maybe we don't muddy those waters.
Yeah, Mr. Chairman?
Mr. Treasurer.
I guess, I would think of it as kind of like a Supreme Court justice, that they serve on the Supreme Court, but when it gets to actually voting on something that they should recuse themselves of, they recuse themselves, and they're not part and parcel to the final decision.
And Madam Auditor, I see Steve was coming forward. But Devin, I think this is really quite to that point we were asking about early on. If you look at the ag industry, if you look at oil and gas industry, if you look at the legal profession, there are certainly areas where people participate in lawmaking, rulemaking, where I think Wyoming law says you have to indicate if you have a direct conflict of interest. But I think, Auditor, if Mr. Kinney can help us sort of refine that notion, I appreciate your consideration, but I do think that as long as an individual or a company is providing advice, and that advice is out in the open, to the degree that that advice precludes other competitors from participating, that's a challenge. But where they're simply helping to build a framework, that certainly is well within the tradition of how we've built this government. That's my interpretation. So, Mr. Kinney, I guess that's not for you to answer today, but I think that's one of the fine points that we should put forward in that, kind of guide that we have beforehand. Because I think Wyoming law is pretty clear that if you perceive a conflict of interest, you should indicate it, and where you need to, you can step away. Is that a correct comment?
Yes, Chairman Governor. The only wrinkle would be here is that this, and I think this is why we would need to look at it more closely before answering it definitive on one or the other, is that this, unlike the others, there's just a general conflict of interest statute. There is actually specific conflict of interest language. And I think it could be fairly read the auditor's direction. It could be possibly read other directions. I think we would need to look at it more closely before coming down one way or the other. But I do think that is a fair question based on this language.
Yeah. Steve, did you have something you wanted to add to this?
And, and the director of the Center for Blockchain and Digital Innovation. There's a lot going on here, and it's all really positive. And, but to address the auditor's question, one of the thoughts I've been having, and the legislation doesn't contemplate this, but it doesn't prohibit it either, is could the subject matter experts serve really as subcommittee chairs and, allow others that might run afoul of this and to serve as members of subcommittees. And that might also be a good idea, because trying to get 4 people that have diverse enough expertise in this space, considering everything we've been talking about. I mean, we haven't determined whether it's going to be a wholesale or a retail stable token. We haven't contemplated how it's going to be marketed. We haven't contemplated exchanges, or, I mean, I suspect the select committee has, but this committee is going to have to do that as well too. That there might be an opportunity there to think a little bit outside the box. And as you're making your selections about who the subject matter experts are, if there's a framework of what you want them to do, such as chair a committee on technology who brings in the subject matter experts that do that. Someone else who brings in, legal expertise. It may change the way you look at who the 4 members are if you're looking at it to be a structure of subcommittee leadership as opposed to individual subject matter expertise. So I just wanted to offer that up to the committee, and I'm not sure if that, I agree with the concept of keeping the group small from a decision-making standpoint, but this is going to be a pretty big hill to climb, considering all of the questions that have to be answered, dealing with the regulatory issues, not only here in the United States, but abroad. And trying to do all that in 6 months, I think would be daunting for anybody. And to add the complexity of a government doing it and following, procurement rules that often private industry doesn't have, this is going to be a tough task. And something else that may be necessary to look at too is I've spent most of my career prior to joining the university in new product development. And often, to comply with the legislation, we might want to just develop a, what we would call an MVP, a minimally viable product that satisfies the statute and, launches a token, maybe, I think Charles Hoskinson mentioned, into a treasury to comply with the law, and then take some time to build this right. And because the world will be watching this. And I think making sure that we do it right is probably more important than just doing it quickly. Now, we can do it quickly and right, but the timeframes that we have here are going to be challenging. I've launched a number of tokens in my life, and this is a tight timetable. So just wanted the committee to contemplate maybe there's a structure that works. Thank you very much.
And thank you very much. Any questions? To the auditor's point, that was a little bit the reason why I laid out the timeline as I did, because we have recommendations of people. We are not putting the cart before the horse. We are kind of getting the cart and the horse and everything all there at the same time.
Well, and Mr. Chairman, I do think there's a difference from receiving general advice as a very small commission, which we will, either through public comment or somewhat more formal working groups with advice. I think that is distinctly different from from actually being in one of these named 4 spots formally on the commission. And I just, looking to keep this as clean and as possible and transparent and keeping us on the straight and narrow, as you said.
And thank you, Auditor. And, Senator, I don't know if this is your intent, but I am sort of looking at this as kind of, at least in the initial stages, as open source. So.
Yeah, on that, I think that is one of the biggest concerns I have with how procurement proceeds, and the fact that we can work within this, but we need to be thoughtful. It does need to be open source, and it needs to be open technology neutral. It needs to not pick winners. There's a lot of concepts that I think are different from typical procurement, where you just point to somebody you hire, that's the lowest cost bidder, and that's who we're going to go with. In this circumstance, the long-term desirable outcome would be to have multiple partners on the financial side, multiple partners on the blockchain side, and not to be restrictive. And that also then probably changes things when you're contemplating conflicts of interest. What we would aspire to is a framework where willing partners that met certain criteria were welcome as partners. That's not a traditional procurement, but it's not against procurement policies, to my understanding. So that'll be kind of a challenge, but I think it's the only way we can achieve the requirements of the market and of the sector.
Thank you, Senator. I think we're getting close to the end of the meeting here, and I apologize. It's good conversation, but I see someone who would like to address the board, please.
Thank you, Mr. Chairman, government members of the commission. I had the privilege of flying up from California today, so I appreciate the proceedings. My name's Les Borsay, and I've been involved in digital currencies since 2013. In 2018, I was a co-founder of a registered investment advisor. I think one of the only ones still standing. Fortunately, we weren't impacted by any of the implosions in the market. And really the purpose of coming up was not only to support the activities that you were moving forward on, but to offer services. We were regulatory from day one, first with California, and then with the SEC. We had to go through the process, we had to go through the audits and continue to, had to go through all the right administration. So we can probably shed a lot of light on who the good providers are, because we really are traditional finance. So we're obviously happy to do that. And as a final note, even on our board, we have a former SEC commissioner, we have a former interim White House Attorney General, and at the company we have a former criminal investigator and cryptographer from the IRS who was there for 15 years. So I think we could probably help. We do work with most of the folks in crypto.
Thank you, Mr. Forsythe. Can we make sure we get your contact information and so on? Betsy, is that a possibility?
Yes. And Mr. Chairman, you've asked this group outlines and inputs, and I think people are going, well, where would I send that? So it's up to the commission, obviously, but I'm happy if I'll draft Matt Sackett, the auditor says it's just her, that we would post something on all three of your websites saying, if you would please submit, if you have information that you would like to submit that was requested at the meeting. And then I know we're still working on the conflict of interest aspect, but if you are interested in serving as a subject matter expert, please submit your qualifications, and that would give them a place to go and submit information that we could gather up and get to you guys. Does that work, or is that not, I don't know what the commission wants to do, but that's just a proposal.
Madam Auditor.
So, Mr. Chairman, I'm sorry, did you say there's an email address set up that we can reference people to from our, and I'm happy to post it on my website.
Mr. Chairman, I think we would work with IT to
Gotcha,
figure out
okay.
just some type of, almost like a notice, though that's the next thing you do need to talk about is when you want to have a next meeting, but it'd be more like a notice. And if you would like to submit information, and I think we have two categories of information. We're talking about expression of interest as a subject matter expert on the commission, but then also you've kind of asked for information about what would be, what are some outlines asked, what would be thoughts that we should look at in hiring a consultant and hiring an executive director and these types of things. And we could kind of put two link throughs where people could, and whether it's like by email and somebody gathers up all the emails and summarizes those for you or submits all those to you at one point. But that was just my thought as to how everybody could submit what you've asked for.
Can you get like a Google share that we can all access so we know what's being posted?
Yeah, we can do that.
Yes.
Great.
All right.
I mean, I don't want to the auditor's point, there is no administrator for this group, so I don't want to try to take over. I'm assuming when the executive director gets hired, they will become your administrator. But just to try to help the process and gather the information, I think our office could work with Matt.
Thanks. Thanks, Betsy. Well, good. Further comments from the public? Further comments?
My name is Rick Poach. I am a precinct committee member from 4-9, and I have also been in the development space for about 30 years, specializing in open source and Unix platforms. I got into specifically Bitcoin 2 years ago. I do have some comments after reading the bill last night, and I will try to keep these short because I don't want to take up time from other people. I should mention that I am not interested in being one of the people on the board, but I would make myself available for any questions. I do not believe that I have the required expertise that you would be looking for. But as far as a public advocate, if you had any questions, I'd be glad to answer that. The first thing that that I have is in section 4031-106, Wyoming stable token accounts, section B, it says, not less than 100% of the notional value of all outstanding issued Wyoming stable tokens shall be maintained in the Wyoming stable token trust account. And I'm wondering what that is backstopped by. And specifically, what I'm trying to get at is, at what point does the token get liquidated? At what point is it deemed to be not viable and it gets pulled? Now, I'm not looking for a response here. That's a question that I think needs to be looked into, but it's not specified in the bill. The second point of interest that I have here is section 4031-106, section A. The commission shall invest funds within the account exclusively in United States Treasury bills. That's concerning in that the recent bank failures have in fact been banks that have invested in Treasury bills. There's also a question as to whether or not with the talks of a upcoming CBDC, I have questions of whether or not T-bills will just be invalidated by the CBDC. I see nothing in the bill that when looking into the legality of if it can be done, I see nothing that looks into the feasibility of should it be done economically. And of course, I'm not looking for an answer at this point. Section 2, point A and point B, rather than read them out, the discrepancy of the dates that are given. Having worked in IT for a very long time, I'm going to tell you right now that a 2-month window to get the issuance of a token is probably pushing it just a bit. So this leaves an interesting dilemma that you have. Do you start development before you know whether it's legal, before you know whether it's or not it is economically feasible or not? So I think one of the ways to address that, as Senator Dreyfus said, the issuance can just be done in a dev sandbox, one token. A clarification of that in the bill might be good. When I read the bill myself, I was thinking you're looking for a finished product in what could technically be 2 months, and that's a little short. So that might help clarify. And the last point is that Section 4, you've earmarked $500,000 to get this done. That's going to be paying off the 4 people on the board, paying the consultants and the developers, the management and the developers of the consultants. I'm not sure that that's really a lot. I think that's going to be burned through quickly. And those are my comments. Thank you very much for hearing me, and I yield.
Thank you very much for your comments. Further comments? If there are none, I very much appreciate you all being here today. This is an investigation as much as it is a product we want to deliver to the last commenter's comments. But I think we have a good starting point. It'd be great to get to work from those who have been here today. I think starting to think about a consultant and starting to think about an executive director. I think we'll probably, and I'm speaking kind of theoretically. Betsy, my sense is we'll probably try to have another meeting here, next month and try to get it formally noticed. But in the meantime, we'll be diligent in proceeding. Brian, I'm going to ask, just because you're the IT person in my office, is it possible to consider putting up a website dedicated to this particular issue? You don't have to answer that now, but I would like to have I'd like to have a landing page which could have access to the sort of shared document that the treasurer was talking about, but as we see the concept work itself out, we could continue that. And that way it doesn't have to be it could be linked to each of our pages, but okay. Thanks. Well, thank you all very, very much. It's 3:05. We're 5 minutes past our deadline. I apologize for being 5 minutes late. So, thank you.
Good job.